20 weeks. That's how long it now takes to register the one document that decides who is allowed to touch your money, if you can't. And that number has been climbing. Before the pandemic, it was 8 to 10 weeks. In 2023, it pushed past 22. It sits at around 20 now, 4 to 5 months in a queue, for a single sheet of paper. Here's the part that should stop you where you sit. That queue is not the deadline. The queue is the easy bit. The real deadline has no date printed on it at all. It's the morning your own mind can no longer sign the form. A stroke, a fall, a diagnosis, and from that morning the document can never be made. Not by you, not by your husband, not by your daughter, not by anyone. Miss that morning, and the only road left costs your family well over £2,000, takes 4 to 6 months, and ends with a judge, not you, choosing who runs your life. Nobody is going to write to you about this. Your bank won't, the office of the public guardian won't, your pension provider won't. There's no letter, no reminder, no red envelope. The system simply waits, quite politely, until it's too late, and then it explains the rules. Most videos on this will tell you a lasting power of attorney is a good idea to have. They stop there. They don't tell you the window is your own capacity, that it slams shut in a single day, or that the people who make it pay almost nothing, and the people who miss it pay thousands. That's the whole story. And that's what we're doing today. My name's Julian. I've spent my whole life around tax, estates, and everything to do with pensioners, and for the last few years I've been sitting with people one-to-one. The ones who come to me are nearly always the ones who caught it too late. A parent already in hospital, the bank account already frozen. And it's the same conversation every time. A conversation that never needed to happen at all. If you know somebody over 60, a spouse, a parent, or it's yourself, send them this while it's still theirs to fix. That one share is worth more than anything I'll say in the next 20 minutes. 4 things today. What this document actually is and the gap you already have. What it costs to do and the far larger cost of not. How the window moves and the exact day it shuts. And then the 4th thing. Stay for the 4th because it's the one that decides who controls your money and your care if you can't. And it's the one nearly everybody leaves until the precise week it can no longer be done. Let me clear up the biggest myth first, because almost everyone in that chair believed it on the way in. They believed that if something happened to them, their husband or their wife could simply step in. Same address, same joint account, married 40 years. Of course, she can manage the money. She can't. Not automatically. Marriage gives you many things. It does not give you the legal right to manage your partner's money if their mind goes. The moment a bank learns that one account holder has lost capacity, that person's access is frozen, and being the spouse does not unfreeze it. The building society will be sympathetic, and it will still say no. That's not cruelty, that's the law, with no instruction from you on file. The instruction is the lasting power of attorney. It's you, while you're well, writing down who's allowed to act for you if one day you can't, and giving them the standing the bank will actually accept. There are 2, and you need both, because they cover 2 different halves of a life. The first is the property and financial affairs one, the form's called LP1F. That's the money one, your bank, your bills, your pension income, selling the house if it ever comes to that. The second is the health and welfare one, LP1H. That's the care one, where you live, who looks after you, your medical treatment, and, if you choose to grant it, decisions about life-sustaining treatment. 2 documents, different jobs. Most people make both. And here's the rule that causes all the heartbreak, so I'm going to say it plainly and then say it again. An LPA has to be registered with the Office of the Public Guardian before anyone can use it. An unregistered one, signed and sitting in a drawer, is worthless to the bank. And it can only be made, only signed, only registered, while the person it belongs to still has mental capacity. Read that twice. You cannot make it for someone who has already lost capacity. The one moment you'd reach for it is the exact moment it can no longer be created. That's the gap. If you haven't done this, you don't have a small problem you'll get to. You have an open door with nobody standing in it, and you won't know it was open until the day it needed to be shut. So that's one. Now the money, because the numbers here are almost comic in how lopsided they are. Doing it now. It costs £92 to register each LPA. That fee went up from £82 in November 2025, so don't trust an older figure. Both documents together, £184. And for a great many people it's far less than that, but hold that thought because it belongs in the fourth part and I don't want you to miss it. Not doing it. Here's the ladder, and I want you to find your own family on it. One document, done at the kitchen table while you're well, £92. One afternoon of signatures, with a fee reduction you may not even have to pay, closer to nothing. Or the other road, the one you're forced onto if you leave it too late. Your family has to apply to the Court of Protection to be made a deputy. That's around £370 just to apply. Then £320 every single year after that for supervision for as long as it lasts. It takes 4 to 6 months. And across 5 years it runs well over £2,000 to be granted by a judge permission to manage the money of the person you've loved your whole life. Let me put two people side by side, because that's the only way the gap becomes real. Two men, both 72. Both have a stroke in the same week. Neither can manage his own affairs anymore. The first man signed his LPAs at 65. It cost him under £200 and one quiet afternoon. His wife walks into the branch, shows the registered document, and by the end of the week she's paying the bills, moving the pension, keeping the house running. The admin is a footnote. She gets to spend the hard months at his bedside, not on hold. The second man meant to get round to it. Same stroke, same week, same devoted wife. She walks into the same branch and is told the account is frozen and there's nothing they can do. She spends the next 5 months applying to a court, paying over £1,000 in fees, filling in forms, waiting, while the mortgage-free house cannot be touched and the heating bill sits unpaid on the mat. She's grieving a man who's still alive, and she's doing it in a queue. Same love, same money, one signature between them. And nobody wrote to the second man to warn him. The bank knew the rule. The pension company knew the rule. Not one of them is required to tell you the day before it matters. They're only required to apply it the day after. So that's 2. Now the deadline, properly, because there are 2 clocks running, and most people don't see either. The first clock is the queue, and it's slow on purpose. You send the registered application to the Office of the Public Guardian and, by their own service standard, it can take up to 20 weeks to come back registered. On top of that, there's a waiting period of 4 weeks built into the law before registration can even complete, so anyone you've named to be told has the chance to object. And if you get one signature in the wrong order, and people do, constantly, because the order matters, the whole thing is bounced back, and you go to the back of the queue. From posting to a document your bank will accept, you're realistically looking at months. The second clock is the one that terrifies me because it has no face and no numbers. It's your own capacity. And it does not tick down politely. It can stop in an afternoon. A stroke on a Tuesday. A fall. A diagnosis that arrives faster than anyone expected. And the moment it stops, the first clock is irrelevant because there's no longer anything you're allowed to send. The queue only exists for people who acted in time. This is what falls off the window, and exactly when. The day you lose capacity, you lose the option, not the paperwork, the option itself. You cannot backdate it. You cannot argue it. There's no hardship route, no "but we were married," no sympathetic exception. The Office of the Public Guardian cannot register an LPA for someone who's already lost capacity, and no solicitor on earth can either. It's simply gone, and the court is all that's left. So there's your accusation again, and it has sharpened. Nobody writes to you the day before you lose the right to sign your own name. The bank, the pension, the council, every one of them holds the rule that will freeze your family out, and not one of them is required to warn you while you can still act. They'll only explain it once the door has already closed behind you. So that's 3. This is the section I told you to stay for, and I want to change the feeling in the room because so far this has all been loss, and I don't want you to leave frightened. I want you to leave able to act tonight. Here's the reversal. This is not, like so much on this channel, money the taxman has quietly taken. This is the opposite. This is the cheapest, simplest, most powerful piece of protection in the entire British system, and the cruelty of it is only that nobody tells you how cheap and simple it actually is. You do not need a solicitor for a straightforward situation. You can do the whole thing yourself, online, on the government's own website, gov.uk, Make a Lasting Power of Attorney. It guides you through, it checks as you go, and it's designed to be done at your own kitchen table. People pay £300, £400, £500 to a firm for something that, for an ordinary set of affairs, they could have done themselves for the price of the registration alone. And that registration, here's the number I held back, £92 is the full fee, but a great many pensioners never have to pay all of it and are never told. If your gross income is under £12,000 a year, you pay half, £46. And if you receive certain means-tested benefits, guarantee pension credit is the big one, you may pay nothing at all. Nothing. The most important legal protection you'll ever sign, free for the people who qualify, and almost none of them know to ask. One warning, from the 2nd of February 2026, universal credit on its own no longer gets you the full exemption, so check the current list rather than assume. So the true cost, for the very people who worry most about money, is often £46, or £0, and one afternoon. And while you've got that afternoon, do 2 more things at the same desk, because they're the quiet companions to the LPA, and they protect the same person, the one you'd leave behind. Find the nomination form for every pension you hold, sometimes called an expression of wishes. That's the little form that tells the pension scheme who receives your pot when you die. If yours was filled in 15 years ago, the names on it may no longer be the people you'd choose, and the scheme's trustees are not obliged to guess right. They follow the form. 1 phone call to each provider updates it. And look at your will. Not a rewrite, just an honest read. Does it still name the right people and the money and property you actually hold now? If the answer is, I'm not sure, that is the answer. And it's a morning's work to fix. Because the thing all 3 of these really buy is the same thing. They mean that if the worst happens, the person who loves you doesn't have to discover, in the worst year of their life, newly alone, that they can't pay the heating bill, can't reach the pension, can't act, and must ask a court for permission first. You're not filling in forms. You're making sure they never have to sit in that chair I keep sitting across from. So, that's 4. Now, let me be straight about who this does not apply to, or where it would waste your money. Because a video that tells everyone to do the same thing is selling, and I'm not. 1. If you've already made both LPAs, registered them, and nothing in your life has changed, your attorneys are still the right people, still alive, still willing, then you're done. Don't remake them. Don't pay again. Put this on for someone who hasn't. 2. If your affairs are genuinely straightforward and you're comfortable following an online form, don't pay a solicitor £300 to £600 for it. Do it yourself on gov.uk for the registration fee alone. Pay for a professional only where it's genuinely complex, a business, property abroad, a blended family, or anyone likely to dispute it. Then it's money well spent. For a simple estate, it's money wasted. 3. If you're in Scotland or Northern Ireland, the English forms and fees I've quoted are not yours. Scotland has its own system, a continuing power of attorney for money and a welfare power of attorney for care, registered with the Office of the Public Guardian in Scotland. The principle is identical, the urgency is identical, the paperwork is not. Look up your own nation's route. 4. The form cannot be forced, and it shouldn't be rushed blind. Choosing an attorney is choosing who holds your money and your care in their hands. If there's genuinely no one you'd trust with that yet, don't scribble a name in to tick a box. Think about it properly first. But think about it now, this month, not one day. 5. The health and welfare one only ever takes effect once you've actually lost capacity. So if you're well, it sits in a drawer doing nothing, and people use that as a reason to put it off. I don't need it yet. But yet is the entire trap. The whole point is that it must exist before the day you need it, because on that day it can no longer be made. And one last figure to leave you steady rather than scared. The Office of the Public Guardian registers over 1 million of these every year. This is not a morbid, tempting fate thing to do. It's one of the most ordinary acts of care there is. 1 million families a year quietly getting it right. So, 4 things. What the document is, and the gap you already have if you don't hold one. What it costs, under £200 to do, well over £2,000 to have skipped. How the window moves, a 20-week queue sitting behind a deadline made of your own capacity, a deadline with no date and no warning. And the part I asked you to stay for, that this is the cheapest protection in the system, often £46 or free, done yourself in an afternoon, alongside the pension nomination form and an honest look at the will. And the thread through all of it. Nobody writes to you the day before you lose the right to sign. The bank, the pension company, the council, every one of them holds the rule that freezes your family out, and not one is required to warn you while you can still act. They explain it afterwards. This video is the letter none of them will send. So here's exactly what to do, and you can start tonight. Go to gov.uk and search Make a Lasting Power of Attorney. Make both, the Property and Financial Affairs one and the Health and Welfare one. When you reach the fee, don't just pay £92 each on autopilot. Check whether your income or your benefits mean you pay £46 or nothing. Then, the same week, ring each pension provider and ask to update your nomination. Say plainly, "I'd like to update the expression of wishes on my pension." And read your will with fresh eyes. Now back to that number we started on, 20 weeks. Post the forms this week, and the 20 weeks starts today, and it ends with your family protected. Leave it, and the day you finally need it, there's no queue left to join. Because the one thing you cannot send the Office of the Public Guardian is an application for someone who can no longer sign it. The people whose families cope in the worst year won't have been cleverer than you. They'll simply have been the ones who signed while it was still theirs to sign. Tell me one thing in the comments. Did you know you can do this yourself on gov.uk without a solicitor, and often for half the fee or none of it? Yes or no? I read every one, and the things you tell me you'd never heard of are exactly what become the next videos.